An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Chisholm versus Georgia, 1793. The first major constitutional controversy to be decided by the Supreme Court involved the constitutional limits on state power, in particular, whether the Constitution permitted a state to be sued by a citizen of another state in federal court. During the Revolutionary War, the Executive Council of Georgia authorized the purchase of clothing from a South Carolina businessman. After receiving the supplies, Georgia did not deliver payments as promised. In 1793, after the merchant's death, the executor of his estate, Alexander Chisholm, filed suit against Georgia in the Supreme Court, invoking its original jurisdiction. At the time, the Supreme Court convened in Old City Hall in Philadelphia. This suit raised an important question of first principles. Could Chisholm even sue Georgia? Article 3, Section 2 lists several heads of the federal court's jurisdiction. One portion of this clause provided that, quote, "The judicial power shall extend to controversies between a state and citizens of another state." Chisholm, a citizen of South Carolina, sought to sue Georgia, another state. Study guide. The Constitution lists a state first and citizens of another state second. Does it matter whether the state is the plaintiff or the defendant? Georgia objected to being a defendant in such a lawsuit on grounds of its sovereignty. Georgia argued that the state could not be sued in federal court without its consent. The state didn't even make an appearance to defend itself. By a vote of 4-1, the court ruled in favor of Chisholm. Unlike the nations of Europe, which are headed by sovereign monarchs, the states do not have immunity and could be sued in federal court. Each of the 5 justices wrote a separate opinion to explain his vote. Each opinion was then delivered separately, or seriatim, from the bench. First, Justice John Blair, relying on the text of the Constitution, rejected the doctrine of sovereign immunity that existed in England. Quote, "The Constitution of the United States," he wrote, "is the only fountain from which I shall draw, the only authority to which I shall appeal." He added that the states gave up whatever sovereignty they had by adopting the Constitution. Second, Justice James Wilson, who was a lead drafter of the Constitution, relied primarily on what he termed, quote, "the principles of general jurisprudence." Wilson rejected the term sovereignty altogether. He began by noting that, quote, "To the Constitution of the United States, the term sovereign is totally unknown." Rather, Wilson characterized the individual free man as an original sovereign and states as mere aggregations of individuals, a collection of original sovereigns. Quote, "Laws derived from the pure source of equality themselves," he said, "must be founded on the consent of those whose obedience they require. The sovereign, when traced to this source, must be found in the man." Referring to the first 3 words of the Constitution, he explained that, quote, "Our national scene opens with the most magnificent object which the nation could present. The people of the United States are the first personages introduced." Finally, Wilson turns to the text of Article 3, Section 2. By ratifying this provision, Wilson says, the people of Georgia had consented to the jurisdiction of the Supreme Court when the state of Georgia was sued by a citizen of another state. Quote, "As to the purposes of the Union, therefore, Georgia is not a sovereign state." Study guide. Do you see a different conception of popular sovereignty in Wilson's opinion than we are accustomed to today? Third, Justice William Cushing concentrated on the text, in particular the wording of Article 3, Section 2, that made no reference to whether a state was the plaintiff or defendant. From that wording, he concluded that states could sue or be sued in federal court. The fourth majority opinion came from John Jay, our first Chief Justice. Jay was the 3rd co-author of the Federalist Papers, along with Alexander Hamilton and James Madison. Chief Justice Jay explained that before 1776, The Americans were subjects of the king and owed allegiance to him. From this, Jay concluded that, quote, fellow citizens and joint sovereigns cannot be degraded by appearing with each other in their own courts to have their controversies determined. Study guide. Did Chief Justice Jay articulate an individualist or a collective conception of we the people? Although he was the lone dissenter, Justice James Iredell's seriatim opinion appears first, indicating he delivered his opinion before the others. Iredell noted that in England, the king has absolute sovereign immunity and could not be sued. When sovereignty was transferred from the king to Congress, neither the Constitution nor Congress expressly abandoned the concept of sovereign immunity. Therefore, following the principles of old law, the suit against Georgia should not be permitted. Chisholm was decided in February 1793. The decision quickly became unpopular among state legislatures. In response to state displeasure, in March 1794, Congress introduced an amendment to the Constitution that would have made it impossible for Chisholm to sue Georgia. In February 1795, 2 years after the decision in Chisholm, the proposed amendment was ratified as the 11th Amendment. The 11th Amendment modified Article 3, Section 2 of the Constitution. Originally, the judicial power extended to controversies between a state and citizens of another state. Now, while a state can be a plaintiff against another state or a citizen thereof, a state cannot be a defendant in a suit by a citizen of another state. After the ratification of the 11th Amendment, it would be impossible for a citizen of one state to sue another state. However, the text of the amendment did not expressly address the opinions of the majority, which concluded that states lack sovereign immunity. Indeed, it is noteworthy that, like the original Constitution, the 11th Amendment does not invoke the concept of sovereign immunity at all. It simply bars states from being sued by citizens of another state. Study guide. Does the 11th Amendment bar a citizen from suing his or her own state? This question would not be addressed by the Supreme Court until its 1890 decision in Hans versus Louisiana.